All right, we've got plenty of time for questions, so let me see hands. Questions and points.
After the Graham Linehan tweet, I just wonder what incitement to violence actually was. So I Googled it. And the only thing I came across was Section 4 of the Public Order Act, which talks about provoking violence. But in the CPS guidelines, it says there's an immediacy test based on Horseferry magistrates and R. And I want to know, what is that immediacy test and how does it apply? And would it mean a tweet couldn't possibly be prosecuted under Section 4 because it obviously wouldn't be immediate?
Great, thanks. Here?
Yeah, the difference is in Scottish law and English law. We can actually be prosecuted for what we say in our houses. And is there something the panel would suggest of that being wrong as well? And how can we go back to a more simple law, which is more understood?
Great.
Is it simplification of the law that we need?
I joined the Free Speech Union a couple of years ago when I was working, thinking I was bound to say something at some point in the university that was going to really piss someone off. Luckily, I'm retired now. But some of the things that we've mentioned that are right, the Lucy Connolly thing and the Graham Linehan thing, and I'm finding myself constantly remembering that free speech is really important, to kind of not get involved in whataboutery when it comes from the something I disagree with. So it's easy to uphold free speech, as we know, when you agree with what the person's saying, and much harder otherwise. The question that I've got, and for me, so the rule of thumb for me, and I liked what Bryn was saying about the command to shoot. So anything where someone says kill someone, it kind of, even if it's not immediate, it kind of rankles. And I wonder why you can say in a tweet from somewhere something that doesn't say kill someone, but when it's somewhere else, like whatever it is, kill TERFs, kill Zionists, whatever. There's no immediate pouncing in the same way there seems to be pouncing. So there's the two-tier thing. What I don't understand is when, and I'm not picking on anyone here, hopefully. Well, yeah, I am. And so when an imam it says something like it's okay to stone women. In fact, we can teach you how to do it if you like. Or when they say, or when where there is a correlation between an imam saying something which says that actually, jihad violence is okay, to then correlating that with actual things that happen in our country where there are terrorist attacks. How come are we just not hearing about prosecutions, or what?
Thank you.
Two things I thought were interesting I spotted recently. One, there's a project called Pre-Bunking at Scale, which is a European Commission project, and it's funded by Google. And the idea is that they use AI to sort of monitor and then generate responses to sort of dehumanizing and factually inaccurate claims about refugees. I thought that was interesting. And then on Friday, I saw the latest attack ad from the Republicans in the Senate made using, it was entirely a deep fake, actually, about a real person saying and doing things they never would have done. And there was a tiny little sort of disclaimer or imprimatur telling you it was, but it was easily missed at the beginning. And what that makes me think in the context of this discussion, it makes me interested to know how this does play out in relation to generative AI, where there might be quite a complicated chain between what you end up, what the image or the word or the claim or the speech is, and the person deliberately initiating it. It's not saying they haven't. I'm just saying it can be quite complicated, both technically and perhaps legally, to draw the connection. And so I'm interested in how that relates to what's being discussed, how liability is established, etc., etc.
Thank you. As we've got some lawyers on the panel, the non-crime hate incidents, apparently there's 30 a day. And I did hear that Home Secretaries are trying to get them to stop this. But then, is it the College of Policing, or do these incidents go via the CPS? Are they sanctioned by the CPS and the DPP, or is it just the police doing their own thing? So, thank you.
Great. I'll come back to the panel and then I'll come straight back out. So 1 minute each, panelists, responding to anything you like. Bryn.
One thing that's very interesting with how many of us are talking about this phenomenon is that we're all talking about inciting violence. In fact, that's not what the law says. The law prohibits stirring up hatred. And it's very interesting that we pivot. I've mentioned this before. We pivot to talking about, I think, what we should treat as the mischief. It's not inciting an emotional state. It's inciting or encouraging acts that could have concrete effects of harm. So to try to bring in what Stephen was saying, I think the urgent simplification that's needed of the law is to bring it in line with, I think, what our clear moral intuitions are, that the problem is not encouraging hatred in another. Because inducing an emotional state in another person is neither here nor there. Encouraging them to take an action, especially if you know that that action is likely to be carried out or will be carried out, that's a different thing. So for me, the simplification that we need, and I agree there should be simplification, should be let's marry up the law with where our moral intuitions are, that it's actually causing acts that cause harm that we should be looking at.
Great. Thank you. Stephen.
So non-crime hate incidents, again, a great example of our government being tyrannical and then being performatively weak and pretending that they can't get rid of them or they don't know what to do. Just stop believing anything they say now. We've really reached peak lying. Obviously, the government could get rid of non-crime hate incidents if they wanted to. They're not doing it, so it's logical and rational to assume that they support them. I mean, on the drafting, I'm with Bryn. I think we should reduce it, really boil it all the way down. But that just so you know, that involves deleting quite a few offences. Lucy Connolly obviously was done under some online offence, which is different from the one that Bryn is talking about. We need to delete loads of them. And then if we want to have one that is very, very clear, that we all know, and then we can consistently apply it. And I don't like Albie's version of inconsistency. And actually, I don't want to embarrass Albie because he's lovely. So instead, I'll embarrass. Please try. Well, instead, I will embarrass Dan Hannon, who it is not inconsistent if when the side of the Angels is prosecuted and put in prison over a tweet, or Graham Linehan is hounded, and then the bad side, the left, say something, it's not inconsistent to call for rules to apply for them. And so all I really want is one very simple rule that is so clear that you can become the moral arbiters of whether or not it's been consistently applied or not. And looking for that consistent application, that is how we beat tyrants. That is how we set ourselves free. And then it won't matter whether you're left-wing, right-wing, Dan Hannon or not. You will just all know whether the rule has been consistently applied. That will be freedom, which is what I want for us.
Thank you very much.
On this point that you, sir, at the front made about this immediacy test, I think that is quite interesting, especially when we talk about kind of online things that are said in protest, and we come back to this discussion about inconsistency that I think Stephen thinks I disagree with him on, but actually I think we might actually agree. But let's take this gentleman, Samuel Williams, Oxford student, who's recently been arrested in Oxford for an anti-Semitic chant that he said, Gaza, Gaza, make us proud, put the Zios in there. Doesn't even rhyme. It's just a crap chant, and I don't know why he workshopped it, but how many people were involved in that? But he's been arrested, right? And I just wonder whether or not the people who were outraged at Lucy Connolly being arrested for the tweet that she said that Joanna read out are as outraged at Samuel Williams being arrested because he made an anti-Semitic chant which wasn't immediate in Oxford. And this is what I mean about inconsistency. Now, I don't really take a view on whether or not they both should have been arrested or they shouldn't have been arrested at all. But if I was to take a view, it would be the same view on both. And I think that's what frustrates me about the politics of the inconsistencies of incitement of violence or stirring up hatred, is that if it's stirring up hatred against people I like or I agree with, I take it more seriously than if it's someone I disagree with. And that's what I don't like. And I think we see too much of it in commentary, and we're starting to see it in politics, and that really concerns me.
Great, thank you. And Joe?
I certainly think simplifying the law would be to the huge benefit of everyone in this right now, if that was even on the horizon, which it doesn't seem to be. But I think more importantly, it just seems that we have a huge separation between the law and policing, between the law and the way the law is actually enacted by police officers. When you see video footage of police officers going to knock on people's doors to say you've upset someone on Facebook, or in a WhatsApp chat you complained about the school that your children go to, this is not a question of simplifying the law. There is, my understanding anyway, and hopefully people on the panel will correct me if I'm wrong, there is simply no law that says you cannot upset people on Facebook or you can't complain about your child's school in a WhatsApp group. So we seem to have the law over here and policing over here, and, occasionally they meet in the middle. And I think this is a cliched phrase which just surrounds at the moment, but I think it's absolutely true. The process is the punishment. If you are have police officers knocking on your door, sitting down, confronting you with something that you've supposed to have done, it puts the fear of God up you. You worry about your job. You worry about your children being taken away from you. It's the most horrendous thing you can go through. And this is what police have the power to inflict upon people. So in a way, it kind of doesn't even matter whether this goes to a court of law, falls on the wrong or the right side of the law. The police themselves are inflicting punishment upon people. So yes, simplify the law. But my goodness, if I was in charge, I would force all 7 police officers from the College of Policing down to actually attend some kind of course so that they're absolutely clear what the law actually is.
We'll come out for more questions.
I was earlier at the session for two-tier policing, and I actually asked exactly the same question, which was not fully answered. It was kind of washed down a little bit, so I'll ask the same question again. And I think you're all touching on that quite well. First, how do we measure and how do we grade this blurred line between incitement and hate speech? Second, obviously, there is a difference between what the law states and how the law is being interpreted. Who is to interpret the law? And then how clearly is that being interpreted? And does it apply to all sides equally? And that is the really difficult task to actually define the predictability of that incitement. As it was mentioned earlier by Brian, it's not just the emotional harm, but how do we predict where there could be both potentially physical and emotional harm? And yes, how do we actually measure that? And is that within a legal frame, or is it just within a frame of pure interpretation, and who does it depend on?
The problem with creating a simplified law, which would be clearer, is that sometimes you create such a bland statement, it can be taken out of context and applied in a way that would be silencing everyone. So when you clarify the law, you could create a rainbow statement that could be applied to anyone.
My colleague Laurie Austell wrote a very good article for The Spectator this week where he defended Samuel Williams's free speech rights with his putting the Zios in the ground. It was a very good article, but I was dismayed, I guess not surprised, looking at the comments, and this is in The Spectator, bear in mind, that the top-rated comments were all very scathing of Laurie's article and his argument. And it left me realising that even among conservatives on the right, on people who would be in favour of free speech, this idea that calling for incitement, or what you would think was incitement, to non-immediate violence, so calling for people to be killed or murdered, they see that to be beyond the pale. So I think I just wanted to ask the panel: do you think that if we want
to put this standard in place, this test, whether the incitement must be to a violence and it must be immediate. It can't just be general incitement to killing people. If we want that to be the standard, it seems that it's not just enemies of free speech who we've got work to do with, that actually we want to persuade people on our own side as well.
I teach constitutional law at university, and one of the things we teach is the rule of law. And I think a big theme of what is underpinning a lot of the discussion here today are some of the sort of sub-grounds of what the rule of law means. The rule of law means no arbitrary power. It's one of the key meanings of what it's about. And if we see differential application of the law, or even the perception of it, which is why that chief constable smacked that microphone, because he understands if there is a perception of arbitrary application of the law, that's a very serious concern for the rule of law. But it's not just that; it's also Stephen's point. One of the other aspects of the rule of law is clarity. You need to be able to understand the law. It needs to be public. It needs to be able to be understood. It needs to be access to the courts. There needs to be these are the elements of the rule of law that we teach 18-year-olds in law schools up and down the country. What's great to see, I suppose, in some way, is to see this kind of debate happening in public. But these are matters that we teach our young lawyers all the time. So it's all about the rule of law. It's all about the reduction of arbitrary power. But the most important one of the most important ones, the most relevant ones, is the eighth one. This is all from a guy called Joseph Raz, who wrote a seminal article in 1977 defining the rule of law. The eighth one is the discretion of the law enforcement agencies should not be used to pervert the meaning of the law. And that is one, I think, that is that people are feeling that there is the meaning of the law is not applied in the same way in all possible contexts.
I want to respond to a point of clarification to something that Albie said, because I was at the Reform conference when Lucy Connolly came out on stage and did the podcast. And essentially, Reform were not lionising Lucy Connolly for what she had said. They were showing her as an example of two-tier justice and the state of this country and where that's got to. And Lucy was quite open at admitting that what she said was unacceptable, on the podcast. So it wasn't that Reform were saying it was okay, for her to have said what she said. But it is legitimate for Reform to have criticised what Starmer and several other Labour MPs said about Reform MPs. And Diane Abbott, for example, saying that Nigel should be given or could be given a good kicking, something like that, she said. Why is that not stirring up hatred? Particularly as it has real-life consequences for people like me as an activist who goes on the doorsteps to talk to people. And to me, that actually almost legitimises leftists coming up to us on the street and giving us abuse or worse. So why was that not hatred? Just a question.
Andrew Eborn, Octopus TV. Brilliant, as always. A couple of points. Firstly, Albie's actually right. You have to make sure there's consistency. But secondly, I'd be really interested in the panel's view. If we do change the law, there seems to be a couple of things. First of all, there's intention of the person making the words and causal effect, what's going to happen as a result of it. But also the person listening to those words. So taking Graham's example, Graham Nunningham, his was a joke about kick them in the balls, and trans person, obviously, they're not supposed to have any. That's the whole idea, which is why he made that joke. It was supposed to be a joke. But if somebody takes those words and they act upon it, even though Graham intended it as a joke, I'll be very interested in the panel's views as to how you deal with those potential conflicts.
I'm just thinking that after the Second World War, when the ravaged countries started putting together articles that would protect people's rights, when they started talking about the right to freedom of speech, the communist countries came in and started saying, well, actually, we need to make it all a bit vague. And what has happened is that we've inherited that, and so all our speech laws are exceptionally vague. So Bryn's talking about stirring up of religious hatred. It's exceptionally vague. It would definitely not work in the States. And that's what the state has tried to do, is try to stop the right wing talking freely. But if you look at the left wing and how they are activists, what they do is something different. They don't have speech. They have action. So if you look at what were the Green campaigners called? When they threw the orange paint over Extinction Rebellion, we don't have any laws against that type of activism, and also Extinction Rebellion. Can you remember when they were stopping people on the motorways and they just sit in front of them? We don't have any laws which are very vague stopping that kind of behaviour. So how do we tilt the balance so that the right are able to do their activism whilst the left are able to do theirs?
Thank you very much. Right, I'll come back to the panel, and I think it's worth mentioning the difficult cases that have come up. I do think the Oxford student is a tricky one, and it goes to Bryn's point about the tinderbox moment, because it might be quite difficult to judge when a society is in such a tinderbox moment. You might argue that we are in something of a tinderbox moment when it comes to Jewish people in this country. And so what would you do with that young Oxford student? I'd be very interested to hear the panel's thoughts on that, but feel free to come back on anything. I'll start with Albie and work my way across.
So for the lady that stood up at the back that asked the question about how do we measure the blurred lines between incitement and stirring up hate, I'm a financial analyst. I love metrics for things, but I've been trying to rack my brain as to what a metric could be, and I don't think there could be one. I'd be interested to know if the panel agree or disagree, but I don't know how you could put that into some sort of numerical value. Maybe there's a different way that you could look at it. Who would be the one that decides? Well, if it's in a court, probably the judge. I think one of the things as a layman that I've understood after interacting with the law is you sort of, when you're not a lawyer, you think that things are black and white, but actually things are very rarely black and white, and things depend on how much money you have for a good lawyer, and that might go into what happened to Lucy Connolly. Maybe if she was a wealthy upper-class woman, what happened to her wouldn't have happened. We should have had better legal advice that she could have paid for. That is a fundamental part of law that we've got to be honest about, and I don't hear many Conservatives arguing in favour of more legal aid, for example. So maybe that's something that we all need to think about. To the question that was directed at me specifically, Madam, I'm sorry to tell you, but my opinion is that you're a complete hypocrite. I don't think you can have someone like Lucy Connolly come on stage at Reform, which Reform are welcome to do. I think it would be fair to say that it was celebrated. That's what I meant by lionize. I didn't mean that Reformers thought that what she said was right, or that some Conservatives think what she said was right, or that I think what she said was right. It is that you bring someone out on stage who has, by law, incited violence, whether or not we want to agree with it or not, and then a couple of weeks later argue that a politician that you oppose, describing a policy of yours as being racist, is inciting violence against you. The consistent position to take, if you were angry about Lucy Connolly, would have been to say nothing at all about Keir Starmer. That is a consistent position to take. And that is what frustrates me. It is, if I agree with you, you can never incite violence, or it's very hard for you to incite violence. If I disagree with you, you can criticise a policy, and I can argue that you're inciting violence against me. And then, when a Reform councillor, Finch, is that his name? His surname is certainly Finch, can't remember his first name, gets assaulted, George Finch gets assaulted in the street, you're blaming the Labour Party for something that someone who assaulted George, the person that is to blame is the assailant in that situation, not the Labour Party for criticising a Reform policy and calling it racist. I just think we have to get real. Either it's both of those are inciting violence, or neither of them are inciting violence, and you need to decide which side you're on that.
So picking my side and pinning my colours to the mast here, I don't think Palestine Action should be banned, and I don't think the Oxford student should have been arrested for what he said, despicable though it was. I think, just to expand on that a little bit, I think one of the many, many, many problems that we've got with laws around stirring up hatred and hate crime and non-crime hate incidents is that relying upon the law when we hear words that upset and disturb us infantilizes us. And I think we've been living in this very infantilized situation for decades now in this country. It allows us to abdicate responsibility from challenging these people who come out with such vile statements head on. It stops us having the intellectual muscle to get together and actually challenge what these people are saying, because by calling in the law, you do not have to have that argument yourself. You just call for a top-down state organisation to come in and take the person who said the bad words away. for me, free speech has never meant words just, oh, you say that and you say that, and we all live in a kind of very kumbaya type of way. For me, free speech is so important precisely because I want to hear who is anti-Semitic. I want to know if you're racist, if you're anti-Semitic, please reveal yourself, because I want the power with my free speech to be able to challenge you, to be able to tell you that I think you're vile and wicked and wrong. And I think the problem is we've lost that capacity to do that. The more we have looked to the law to step in and act as a kind of moral guardian on our behalf.
Well, I think that was a brilliant point, well deserving of applause, and I would echo it. It has, this over-reliance on lawyers has turned ordinary people into children. Lawyers are not moral guardians. Judges are not angels made flesh. Vast swathes of my fellow lawyers hate me because I point this out. I refuse to be given dominion over you. I will not wield it. We are servants, not masters. But the way to get it back, and for Albie, it's right to talk about consistency, but what we want is consistency of outcome. We don't care about consistency of Nigel Farage's intellectual position or consistency of what Richard Tice thinks. It doesn't matter. We want consistency of outcome. That's how you restore the rule of law. This is actually the best. This is my 5th year, and this is the best session I've ever had at the Battle of Ideas, because whether you know it or not, you've been engaging in drafting law. You have been talking about which words would we use for our law of incitement. And it should be your law of incitement, and you all should have a national discussion about it. They used to publish in the Times, and then people would write into the Times, go, no, I think that this is, I would tweak that word here. Oh, actually, I would tweak this word here. And again, we would be engaged in it. And it was a process. And Parliament used to do this. MPs used to actually argue over words, not just go on telly, kiss a baby, pick a popular cause, and then vote the way the government tells them. They actually used to engage in all of this. So I'm loving that you're engaging in it. To the lady at the back, this is the way that we get absolute clarity, by working on the wording and thinking it through. To my good friend who mentions Raz and his definition of the rule of law, it's great, but I like to show off. So my definition of the rule of law is in 11 words. Clear rules, known in advance, enforced equally, without fear or favour. That's what we need to get back to. Really clear laws. And that's how you avoid the rainbow language. If you tighten your language, I always point out that my tutor, sorry to go on, Luke, but the best tutor I had at Oxford, she insisted on getting the Sun delivered to the senior common room, which really angered the English dons. They did not like that. They only wanted the Guardian, and they were not happy that the Sun was even there. But she always said that the writers of the Sun have to distill a story down so absolutely that they are lawyers. They are so concentrated in their use of language, and we can all get there. And you've shown me you can participate in this too. I am not some magical little overlord that I hope I don't want to be, and none of them are either. But this has been great. This is how we should live. It should be our law of incitement. We should draft it. We should know what it is. Thanks.
Thank you. Got a 3-part answer. So, in response to the lady at the back asking about the blurred line, the answer as to who interprets our law is obviously the courts. I don't think we should have too many misgivings about that. The High Court still has liberal-minded judges, on liberal-minded in the proper sense of that word. I mean, they take liberties seriously. The problem is not so much one of interpretation, it's one of enforcing liability. When the police get it wrong, they don't really suffer consequences. You'll probably sue them in wrongful arrest and they might bung you 20k. It's not going to turn the tank around. It's not enough of a slap on the wrist to make them mend their ways. If you look at how the police have learnt the lesson and have been severely punished for racial profiling, if you look at how desperately police now avoid anything that looks like racism, that's because the proper levers have been pulled, which is police accountability through the IOPC. Essentially, they worry that they're going to be struck off as coppers. That's what we need to do with freedom of speech. Anytime a copper arrests Graham Linehan, whoever, that sort of arrest, it needs to be asking, you have done something that's not consistent with being a copper in a liberal society. So that's how we need to make them feel the pinch. Second, there's a very good question about AI. I think one thing that is massively blurring the line at the moment is social media. We don't have a proper grip, or we haven't even thought through how harmful is social media. There's a gigantic amount of moral panic about social media as a discourse without gatekeepers, a discourse where the sort of barbarians are at the gate. I think we need a proper discussion. Do social media posts really incite people? Do they prompt action? We've got no idea. Many decisions predicated on the basis they do, but we've got no idea whatsoever. The problem, of course, is that the research apparatus that we've got in our social science departments, they probably think they've got an answer to that, which is social media is terrible and it's full of gammons and it's going to incite violence. But we need proper, open-minded, fair-handed research into that question. The last thing, as Stephen knows, I don't really agree with him on clarity, or rather I do agree on the need for clarity. I don't believe in the need for simplification. Lord Coke, great English judge, said that we must proceed by the golden measuring stick or metwand of law, not the crooked cord of discretion. That's to say, you are able to treat like cases alike if you have a precise enough rule that you can apply it. If you have just discretion, it varies all the time. I think English liberty has traditionally been safeguarded by the granularity of our rules, that we are very precise. Our legislation is always very precise. And that for me has been a safeguard of liberty. If you look at the rights that Napoleon announced for his people, they were incredibly capacious. If you look at the rights the European Convention promulgated in 1950, they were, contrary to the British negotiators, extremely broad. And indeed, they have not proved in any way a safeguard of the liberties that English men and women have enjoyed for centuries. So I think our safeguard is in clear drafting that avoids extravagant discretion. And I think we should keep to that tradition.
Great, thank you. I'm going to come out for one very quick final run. I've got about 6 minutes for questions.
Thanks. I think there's two separate points about consistency. One is legal consistency with what happened to Lucy Connolly, and also there was that obscure kind of Islamist Labour councillor inciting in a political sense a crowd to do violent things, and he was found not guilty because he was advised to plead not guilty, whereas Lucy, under very political circumstances, was advised to plead guilty. So but there's also the political consistency of, in America, someone like Tim Walz saying Trump is a fascist, Keir Starmer essentially saying that reform policies are racist, that Diane Abbott says reform people should be given a good kicking. Now, I think if there's a political consistency, it's not that Diane Abbott is guilty of inciting violence on members of the Reform Party, but that what she did was wrong. And it's the total hypocrisy of the Labour Party and the left, and frankly, some people in the supposed parties of the right going along with that. So there's a need for a political consistency, and also that we should hold our politicians to a higher standard, right? Lucy Connolly was a bereaved mum who'd just lost a kid who deleted her post after an hour. Keir Starmer is the Prime Minister. You know? If you're calling Charlie Kirk a fascist and a racist, of course you shouldn't go to prison for that, but we need a consistent approach to saying that does create the climate where some nutcase will shoot him. Because remember, it's okay to shoot a Nazi. It's okay to kill Hitler if he's a Nazi. So there's a need for a political consistency and a legal consistency. And of course, in the Lucy Connolly case, they overlap because there was definite politics at play when she was advised to plead guilty, when obviously she shouldn't have pleaded guilty.
Yeah, it's a very good point about our political culture. And perhaps the panel would like to address the problem of dehumanizing language in politics, which is, of course, very separate to perhaps questions of law. Who else?
2,500 years ago, Confucius said, if the words do not comply with facts, the justice will not know how to decide correctly, and the people do not know where to put hands and feet. I think that is enough to say, because politics have to do the opposite. They have to look that the people know where to put their hands and feet.
I'm going to express moral intuition, if you will. And I'm going to borrow an analogy from Tibetan Buddhism this time, where the teacher dispenses a teaching upon a disciple saying, look, if you're finding the world hurtful to walk, one option is you can cover the whole world with leather, or you could just wrap your feet in leather. And by that, what I'm trying to say is, if you're finding words hurtful, maybe just seek CBT instead of trying to, bring about laws that will just affect all of us.
Great, thank you. I'm going to take the panel in the reverse order, if I may. So I will start 1 minute summations with Joe.
I'm going to return to a question that was posed right at the very beginning, in fact, in the blurb for this session. Is incitement a tool of censorship? Yes. Yes, it is a tool of censorship. It's a tool of censorship both in the law, but also importantly in our popular understanding of the term and the way that those two things interact. I think my take-home message really from the session today is that defending free speech is hard. It confronts us with very tough moral choices. And to make the case for free speech at the moment, it seems to me that we're having to challenge the law. The law is incredibly censorious in ways that have been outlined. We're having to challenge the police interpretation of the law. We're having to challenge our political opponents who would seek to silence us. But we're also having to challenge our own instincts. My instinct when I hear students like that young man from Oxford coming out with these vile sentiments is that I want to shut him down. That is my instinct. I do not want to have to hear that sentiment. I do not want other people to have to hear that sentiment. And you're kind of in a moral battle with yourself against the instinct to silence and censor. But it's important that we have these conversations, and it's important that we do think about what are the principles that are at stake here. It's an important discussion. So it's a bit of a wishy-washy conclusion, but it's the best I've got.
Wishy-washy is good. Thanks, Joe. Albie.
So, on Lucy Connolly versus that scumbag who called for people's throats to be slit, when it comes to the legal advice they got, even if it was in a political context, I would argue Lucy Connolly was advised very badly and the other gentleman was advised well. And that led to a different outcome in how they were treated, which is where I come back to what I was saying about having a good lawyer and a bad lawyer and whether or not you have the money or the backing to afford one. On the point about Diane Abbott saying Nigel Farage deserves a good kicking and people being outraged at that, were those people also outraged when Graham Linehan said, kick them in the balls? I mean, these comments are both quite similar. But again, when I come back to consistency, you'll get two people on two separate sides of the argument saying one of them is awful and one of them is fine, or the opposite. When actually, I think it's probably fine to say both of those comments, to be honest. Why can't we say to people, that person, my dad in the front, deserves a good kicking because he didn't buy me lunch today? We should be able to say that without someone saying that's inciting violence, for crying out loud. Equally, Graham Linehan should be able to say, as a joke as it clearly was, kick them in the balls if they're in the wrong space that doesn't correspond with their sex, without being arrested by 5 police officers at Heathrow Airport. That's a consistent position to take.
No.
But how is that joining the Labour Party? I've just made a free speech argument there, sir. And if you can't see that is the consistent argument, maybe you should just come out as an authoritarian.
It's not a back and... It's quiet room. Albie, have you finished?
I have finished, yeah.
Okay, can we thank Albie with a round of applause?
Sir, how sharper than a serpent's tooth it is to have a thankless child. That's all I wanted to say about that. But look, I will help you, and hopefully other lawyers will help you draft clear rules, and then you will understand them, and then you can enforce them consistently as law, and then we will have a better country. I'm not against precision. I must have misled Bryn, but that just shows the danger of using precise language and the importance of it. And actually, I think language is made better by collective discussion and by involvement, and that our means of making law, which has existed for quite a long time, was a valuable means of doing it. And what happened was effectively during the EU, all of our laws are written by bureaucrats in Brussels and then sent over to bureaucrats here in order to make a little bit more British, and then the politician's job is just to pass them. And that is a stupid way of making laws. This is not a criticism of the EU. If you love the EU, love the EU, but that is a stupid way to make laws. It's made our laws flabby, fat, and lazy, and we get them better by using precise language and really, really drumming it down. Once we have a legal definition of what we consider legal incitement, because it is a tool of censorship, I think, frankly, I shut up. And I would encourage my fellow lawyers to, if they want to carry on talking at that point, admit that they're no longer experts, because morality is a personal thing. You know, I'm not an expert in morality. How our politicians should or shouldn't behave, moral issue, not for me. Okay, so that I just want to draw that line as well, because I think once we will only get back to a decent country with clear lines.
Thank you very much. Final word goes to Bryn.
Thank you, Luke. I actually very much agree with Stephen that the question of what our liberties are must return to the political sphere and must return to Parliament. Part of the Blairite settlement says that questions of rights are for the courts, and Parliament can do stuff like raise money and spend it. That really was Blair's approach. We must urgently return our liberties, especially our freedom of speech, to Parliament as a matter of the utmost political importance. Why? Because despite what lawyers will tell you about the sophistication of legal reasoning, it's not always as sophisticated as lawyers say. That the deliberations that parliamentarians can have are considerably more wide-ranging, more morally informed than what can be had in forensic debate. The second thing that we need to do, and I think this is an urgent problem, we by default treat law as a problem, treat speech as a question peculiarly calling for regulation by law. If you look at any university code of conduct, it will have define harassment in a legal way. It will use the language of law about what students can and cannot say. The same code of conduct, I guarantee you, will prescribe and prohibit theft. And yet they will never, ever define theft as dishonest appropriation of property belonging to another with intent to deprive permanently. That is to say, we all know what theft is. You don't need the law to tell you what it is. For some reason, we've got it in our heads that language calls particularly for law's oversight. It doesn't, and we've got to get over that hoodoo. It's an absolute error, and it's a blind alley. It's going to lead us nowhere. Last thing I'll say, the Free Speech Union is non-partisan. I agree with many people who say that many on the right have been fair weather friends to freedom of speech. I think this is where culture war inevitably leads us. I think we need to be absolutely principled, everyone, about what free speech is and what it isn't. And that means, yes, if people who are on your side fall foul of it, then you say that. And I think that is where the strength of all political arguments is upon its principle consistency, and we should all aim for that.
Great.